Before we begin with our last panel for the day, I would like to send the warmest regards of Mrs. Margareta Popova, our Vice President-elect, who unfortunately fell ill today. She's really apologizing for not being able to join us. Her speech will be available on our website, sofiaplatform.org. And now I'm giving the floor to the panel.
Thank you. Is the microphone working? Okay. Well, we are at the beginning of the last panel for today. It has been a very dense and sometimes exhausting program. All the members of this panel are lawyers, and as we all know, lawyers like to talk a lot. So I launch an appeal to our fellow panel members to keep it short, if possible, in the range of 8 to 10 minutes, so we could leave a bit more time for discussion. Democratization and judiciary. This is the main topic for this panel. If we look back to the history of Bulgaria, the judicial reform started almost immediately after the democratization process started, with an amendment of the old constitution. An example was very clearly given by President Zhelev this morning. The legal basis for the legal and judicial reforms in Bulgaria were set by the new constitution of 1991. And one of the really greatest achievements it did was in a completely different manner and very clearly defined the role of the justice, of the judicial power in a new democratic society, namely from protection of the interests or protecting the state towards protecting the rights and the lawful interests of the citizens, as it is stated in the Constitution. Basically, it was a tremendous shift in values, although in legal terms it somehow passed not very much noticed. A lot of structural reforms were launched according to this Constitution. The judicial power was reshaped, restructured in a manner to put it as far as possible, to put it away from direct political intervention. This led, in the case of Bulgaria, to a return, at least at the beginning, in the 1990s, to a well-known form and legal and judicial traditions well known before 1944, although reshaped in a somehow modern way. It is kind of anecdotal example. Already in 1997, the Minister of Justice at the time announced that the judicial reform is over. Although it was perceived with certain laugh, basically what happened indeed was the judicial reforms entered into kind of a new stage, from structuring judiciary according to the Constitution towards reforms that aimed to increase its efficiency, aiming to increase and to face the expectations of the society for a modern and effective judiciary. During the last 20 and more years, we faced here in Bulgaria a very dynamic change of legislation, and it seems it is far from being over. On the other hand, the state changed its role from a main actor, as it used to be before '89, towards a role of a regulator, which naturally increased the role of the judiciary as an arbiter between particular individuals, arbiter between the individuals, the citizens, and the state. One of the first things that were done in Bulgaria in already 1992, immediately after the adoption of the new constitution, was, as it was mentioned this morning, politically joining the Council of Europe as kind of an official certificate for being a democratic country. What is more perhaps legally is more important. Bulgaria joined the European Convention of Human Rights, putting a serious judicial mechanism for protection of human rights in place, not only being part of the national law, as it follows from the Constitution, but also adhering to an international mechanism for protection of these values. And there is another phenomenon that we faced. Quite many young people, new generations, started joining the judiciary since basically the early 90s. And it is an ongoing process. In order to face this set of challenges, I'm listing perhaps just a few of them, something that was never been done in this way was established, namely particular attention started being paid to judicial training. Something that is also, in a way, important regardless the national frontiers and differences in political systems. Because only competent magistrates and judges can be also independent magistrates and judges. So with these few introductory words, I would like to present you the members of our panel. You have their details in little books. So on my right-hand side is Mr. Ahmed Maki, until just recently Vice President of the Supreme Court of Egypt, a member of the Judicial Council. Further on my right side, Mr. Iyad Chawashi, do I pronounce correctly your name? A magistrate from Tunisia, member of the Magistrates Association. On my left-hand side, Mrs. Nelly Kutskova, judge at Sofia Court of Appeals and spokesperson for Bulgarian Judges Association. Next to her, Mr. Taoufik Ouanez, a eminent lawyer from Tunisia with very important international background as a lawyer and chief advisor. And on the very end of this row, Mrs. Ivanka Ivanova, director of the legal program of Open Society Institute in Sofia. So with this, I pass the floor to Mrs. Nelly Kutskova first, please.
Добър ден на всички, засичам си времето.
Good afternoon, everyone. I will try to not to take more than 10 minutes. I will start by addressing the title, that is transitional justice. Because the word justice in Bulgaria, in fact, can be translated in two ways in Bulgarian. One of that is justice or jurisprudence or administration of justice, and the other is fairness, a just attitude, the feeling that things are what they should be. Such a difference in the word exists not only in Bulgarian but also in German. Gerechtigkeit is one of the words, and Rechtsstaat is the other one. I heard that this morning some of the panelists reminded you what Stefan Heim said, that we expected from the unification of Germany justice, and what did we get? Rule of law. So there are various meanings in these words, especially when we talk about transition. Then sometimes this difference is significant. And as Bulgaria, in these years of transition, witnessed numerous criticism to the courts, to the judiciary. There is a high feeling of unfairness in the population. So in 2008, we organized a survey, a public opinion poll, to see why people criticize the court so much, why they say that there is no justice. I will just quote one of the analysts, Mr. Harlan Alexandrov, who, based on the sociological survey, came to the following conclusions. The survey reveals that the judiciary as a mechanism regulating social relations in modern societies is not simply unknown to large groups of people, but is furthermore experienced as alien and incomprehensible. The procedural logic behind the administration of justice is beyond the comprehension of the wide public, which instead follows the logic of common sense. Given the degree of incomprehensibility, the conflict between the two systems becomes inevitable, since common sense is guided by the intuitive, retributive ethics, which requires that bad people get punished, whether found guilty or not. Hence the difficulty in understanding how exactly the judiciary stands for values like justice and human rights. Something more, if the popular attitude reduces justice to penal repression, and even the sociologists and researchers seem to be sharing this attitude, as revealed by the biased wording of some of the questions in the survey, then these values turn out to be in collision. The situation is further complicated by the widespread belief that the social world we live in is fundamentally unfair, typical of times of social transition and instability. So this moral deficiency in its turn gives rise to excessive and unrealistic expectations from the judicial system to ensure the order and justice missing in everyday life. So regardless of differences in our countries represented in this hall, we, to a greater or lesser degree, have gone through transition. The people from Northern Africa and Middle East are witnessing ongoing revolution, but they will also have to do this judicial transition. So I sympathize with my colleagues, judges, from whom there will be expectations to administer justice the way each individual understands it. As for Bulgaria, as my colleague Dragomir Yordanov already mentioned, since 1992 we are members of the Council of Europe. My colleague is young, though he does not remember how we became members of the Council of Europe, but I do remember, and I remember how many requirements there were to Bulgarian legislation with respect to human rights application. Then the court was looked as a body of repression which would not respect human rights. With the new constitution of 1991 and also with the consequent changes in Bulgarian legislation, we achieved such a high level of protection of the human rights of defendants that do not exist even in some of the older democratic states. In the years before we joined the European Union and after that, we were criticized that because of the excessive respect for human rights of defendants, Bulgarian court becomes inefficient. So we got this effect of the domino, and now we are between Strasbourg and Brussels being criticized by both. Probably this is something that our colleagues, our counterparts from the Arab Spring will also experience. I hope, however, they will they will take it easier. Bulgarian constitution provides for human rights and also for the independence of the court. Our written legislation really provides for the independence of the judiciary. And in 1993, 1994, the first Supreme Judicial Council was created. Before that, the Minister of Justice appointed judges. We were very happy with the Supreme Judicial Council comprising 25 people, 11 elected by the Parliament, and 11 more elected by the judicial community. So we do have a unique model, which we do not like that much. By the judiciary, we understand courts, investigators, and magistrates. Investigators have legal background. They do investigate some crimes, although most of the crimes are investigated by the police, but we do have representatives in the council, also representatives of the Supreme Cassation Court, and also the chief prosecutor. Unfortunately, across the years, this Supreme Judicial Council was neither so democratic nor so efficient we expected. I'm not going to go in much detail, but instead of fighting for the independence of the judiciary, in the last year, the Supreme Judicial Councils are in conflict with the governments, with those in power. In fact, last year, when the new government started operations against organized crime, and we all admired these operations, with the judges included, because there never were such operations before, it suddenly happened so that the sentences were pronounced by the Minister of Interior, who said in public that with the evidence that they had collected, there is no European court that would not sentence these people in prison. However, for part of these people, we don't even have indictment acts ready. And because of the long period of investigation, some of the measures of detention were changed. The court was blamed for corruption. The Prime Minister, whom you heard today, said in public that in the condition of economic crisis, arrests are the best anti-crisis measures. So 22 years after the beginning of the democratic changes in Bulgaria, we are still in a process of transition. And instead of having a more and more independent court, the executive power tries to dictate the court what to do. I do not want to say that the court is perfect and makes no mistake. No. On the contrary, among us, the judges, there are people who are not good for the job. There was no lustration in Bulgaria. But in the period 1992-1993, many judges were dismissed, mainly senior judges, heads of court, who were linked to the Communist Party. As for collaborators of the state security, this is just what I remember. The Committee for the State Security files disclosed that in the whole system there were 22 people, collaborators, some of which formerly officers with the State Security, because they were investigators. So I would like to say that in the Bulgarian judiciary there isn't so much from the past. There are no retrograde elements. Most of the Bulgarian judges are younger than 43 years of age. But we do have numerous problems. And I would like to say something that probably won't be typical of the Arab countries. But the transition in Bulgaria from socialist economy to market economy went through the court. In your countries, you have other more difficult problems. People were killed, young people, unfortunately. But in these countries, you have private economy and free market economy, while the whole process of restitution of property that was nationalized under socialism, restitution of factories, agricultural lands, etc., etc., all this went through the courts. And the court was involved in the whole process of restitution, also the processes of privatization, whether successfully or not. But for all failures in these processes, criticism was leveled at the court. I would not say that Bulgarian courts are criticized and only criticized. Sometimes there are good grounds for this criticism. But there is a global trend to criticize the court and blame the judges for state problems, for the problems that countries are facing. And I'm not going to talk about Eastern Europe. I'm going to quote the country France that gave the slogan freedom, brotherhood and equality, where the French president dared to blame the court for a criminal, but French people are French people, they went on strike. During transition, it is important to respect international standards of administration of justice. There are international charters in this respect, and in many acts of the International Association, and I know that the Tunisian organization is a member, the installment of standards for administration of justice that are internationally applicable is a good way for justice in our countries. Thank you for your attention.
Thank you, Nelly. I didn't want to find 1 minute over time. Well, with this, I would like to pass the floor to Mrs. Ivanka Ivanova. I think she would emphasize more on the criminal justice. Please.
Благодаря ви, господин Йорданов, за дума.
Thank you, Mr. Yurdanov. I would like to start by reminding you something that President Zhelev said in the morning. He spoke about the trial against the Bulgarian dictator Todor Zhivkov, telling us how then, in the beginning of Bulgarian transition, there were publicly known evidence that the Bulgarian dictator and other members of the political bureau were involved in national treason with respect to political decisions and proposals for Bulgaria to become part of the Soviet Union. And regardless of this evidence, there was a trial against Todor Zhivkov, but for something very unimportant. And what President Zhelev told us, that after long years of court saga, 2 years before his death, Todor Zhivkov was acquitted by the Supreme Court even for this documentary crime. Very few, however, remember this trial. Very few remember the way it ended. But something else that President Zhelev underlined, and something that is very important, is that the fact that there was not a real trial for treason had heavy political consequences that are still looming over Bulgarian transition. This morning, President Zhelev asked the question why the prosecution decided to press charges for administrative crimes rather than treason. Well, for the last 20 years, all and every Bulgarian citizens can raise such questions. Why prosecution chooses to act in this way and not in another way? Why prosecution collects evidence and never acts on this? Why prominent figures go unpunished? Why other people, even when punished, get disproportionately small sentences compared to their crimes? All these are issues related to the efficiency of criminal prosecution. I want to say that the big problem for Bulgaria is that now, 22 years after the Bulgarian transition, all these questions now are in the core of the discussion about the judiciary reform, and it is so late that we understand the political consequences of everything that happened.
Here is the role of the prosecution. The role of the prosecution in the Bulgarian transition and the role of police are important in this aspect. I would like to discuss the question which was asked by President Zhelev. There isn't a straightforward and simple answer. The leadership of these two key institutions, prosecution and police, and the speculation that they were overtaken by the former secret services. It's not really, there isn't a straightforward answer, there isn't a simple answer, but if we have a lesson to give to the countries that are now on their way to democratic changes, is that the facts have to be laid on the table much earlier, and all the factors which allow the efficiency should be formulated early in the stages by the civil society as expectations, as facts. Unfortunately, our criminal proceedings here became too late, and there were several reasons for it. The first reason was that in the totalitarian state, not only the activity of the secret police was covered by secret, all the activities of the police as a whole was secret. We didn't know what the numbers of the regular police was until 2 years ago, when the taboo was removed of the state secret over this information, state secrecy. And you realize that if a society does not know what are the numbers of its police forces, then this society does not know if this police has sufficient resources to do their jobs, and cannot look for accountability if the processes fail due to inefficient actions by the police and other institutions. The Ministry of Interior is still the only institution which does not publish an annual report to give facts about the crime in the country, how it's overcome, what are the impediments, the barriers. when the ministry was led by Minister Roman Petkov, which is 2.5 years, there was a report then, and there was another report which covers the 100 days of the present government, its activity, the activity of the Ministry of Interior during these 100 days. But they cannot give enough facts, enough information to people to make any conclusions about the activity of the Ministry of Interior, and it doesn't allow for the Parliament or the civil organization to raise the questions and issues about the activity of the ministry. Another element is that not only numbers and data to do with crime was a subject of secrecy and continue to be a subject of secrecy, but even the science, criminology, was erased from its civil social circulation. And at the moment, 22 years after the transition began, there are only 2 institutions which deal with it. One of them is the Institute of Criminology, which is part of the Ministry of Interior and is directly reporting to the Minister of Interior. It's a scientific program, is approved by the Minister, and of course the officials of this institute cannot ask questions like how effective the policy of this minister is. The other institution is an NGO, the Center for Study of Democracy, which makes sporadic reports, which are funded with outsourced funds from the United States and the European Union. But within the Bulgarian Academy of Sciences and Bulgarian Sciences, all there isn't independent criminology, due to which Bulgaria is in an absurd situation for the Bulgarian media to name certain people as criminals and state that these criminals are known, and it's known that they're criminals, and we cannot formulate why these people are not in prison. But actually, the facts about crime as genesis, the factors that predefine it, we have not enough facts to discuss it. So if no urgent steps are taken to improve the accountability of the 2 institutions, the prosecution and police, who are in charge of criminal prosecution, we cannot say why one or other person is not in prison yet.
I think both first and the second presentation gave a quite good overview of the problems still faced by Bulgarian justice, particularly criminal justice. I think it is time to pass the floor to our guests and to have a slightly different perspective on the problems they are facing nowadays. I would like to give the floor to Mr. Ahmed Maki to present the point of view of the situation in Egypt. Thank you.
شكرا. بسم الله الرحمن الرحيم. أنا سعيد.
In the name of God, who is all-powerful and merciful, I'm happy that I'm taking part in this forum. For the first time, I'm leaving the Arab world, and I'm in a country which is a member of the European Union and which is also an East European country. I would like you to play the role of a bridge between us and the European civilization, because so far it hasn't had any contact with us. Until now, we can't manage to establish a real contact with the Western civilization. Since the 19th century, when Egyptians started their movement against the Ottoman Sultan, the Turkish Sultan, the Egyptians turned to Europe. The big activist of this movement, Rifat Akhtawi, wrote then, knowing Europe, in Europe I met Muslims without Islam, and we have Islam here without real Muslim people in Egypt. In the same time, in Egypt, the first newspapers were founded, and the foundations were laid of the judiciary. In 1866, Egypt had 1,866 independent organs of management, of governing of the country. So for over 130 years, we have independent judiciary, relatively independent, and although our parliament failed in its activity and our government failed, most of the MPs and ministers are in prison now, but I could say that the judiciary, unlike the experience in Eastern Europe, and here I will try to to acknowledge the differences between the situation in our countries in Eastern Europe. Our judiciary still is some kind of justice which sticks to the rule of law, to the protection of human rights. The Egyptian constitution since 1920 through 23 emphasizes that the main task of the constitution is to protect the interest of the individual, not the state. So we have had the idea of having special legislative bodies, people's courts. From the beginning of the Egyptian system of justice and of law, by tradition, these are relations between the judiciary and the government. The judiciary refuses to become an instrument for oppression of the people and of society. This is a positive point which facilitates our transition. Unfortunately, we haven't started the transition period yet in my country. What actually happened is that we got rid of the previous dictator, but we are still at the very beginning of our revolution. So in the coming days, during the elections, we will probably begin to discuss things in their substance, in their essence, things which are being discussed here. Your experience shows that you had support from Western Europe. In our attempts to lay the foundations of democracy, it's the opposite. We concluded that Western Europe was supporting our dictators, actually. All dictators in our countries during the colonial era were supported by Western Europe, which is due to the fact that they were the best protectors of the interests of Western Europe. Also, this is probably due to the Palestinian problem. Okay. we let Western Europe maintain good relations with Israel, but is it just that we have a people now which is deprived of all its rights, including the right to have its own state? The European Parliament in 2006, I visited it and I met some members of the European Parliament, and we discussed certain process of protest against President Mubarak then. We said that we cannot take a standing against the demonstrations which were taking place according to the new civilization, according to the thoughts and beliefs of people like Montesquieu, philosophers like Montesquieu. We are aiming to achieve a balance between the executive and the judiciary. Although since 1866 we have a parliament in place, we have a government from the end of the 19th century, we continue to suffer from a dictatorship of single persons of authority. In our case, in our experience, we don't oppose a totalitarian regime in its specific connotation of this term. At the beginning of the 60s, in the 20th century, we got familiar with the ideas of socialism, but also with the essence of the totalitarian system. NASA then tried to conduct the idea of a one-party system, but in the Egyptian judiciary, in our legislation system, there is a lot of literature about how our legislative system opposed this idea and was supported by the Egyptian people. In 2005, we had elections, and Hosni Mubarak tried to use all opportunities to forge these elections, including he tried doing it in the presence of envoys of observers from the European Union, from other foreign countries. But our viewpoint, our standing was that this system could not protect completely the interests of the citizens. And in our legal system, we are obligated to do exactly this. You discussed your attitude to the past in respect of the issue with the files of the former secret services. President Mubarak, before he came down from power, managed to destroy all these files. And there are too many bodies and apparatus in the world, but dictators who are not actually existent and present, but our dictatorship was very real. The first 5 or 6 days after the 25th of January till about the 1st of February, bearing in mind that Mubarak resigned on the 11th of February, he used this time to destroy all the archives of our state security. They were burnt in the hope that the ruling will remain in power and they could be protected by this. With God's help, after we finish and bring to a successful end our revolution, and with the foreign experience which we have available, we will try and look for accountability develop a plan how the judiciary, how the legislative system should be working. We have a weak point. I was the chairman of the High Judicial Council, and our problem is that our prosecution is directly subjected to the control of the executive, and in many countries it is part of the executive, actually. So the button by which this system could be moved could hinder its activity and prevent it from protecting the rights of the citizens. Our revolution in Egypt hopefully will leave the judicial system away and separate from the political processes, from the parliamentary work, from the elections. In Egypt, we have, in our tradition, such a view since 1888. We have a decree that the judge in Egypt should be independent and he should choose the people that he will be working with, his direct assistants, provided that they are familiar and their past is well known to the public. We will be using the European experience. We learned a lot from Europe on how we could be really independent, and we must acknowledge this. Thank God, in 1975 in Egypt, the so-called mixed courts of justice were established. 12 European states take part in them, France, England. These courts are the most independent courts in the history of mankind. Although this court functions in Egypt, its members are not Egyptian. This is a court which deals with the court cases of foreigners in Egypt. And now we look at this experience of independence and hope that this will lead us to success in our efforts as the members of this court are its members, provided they are in no way connected or linked to the Egyptian government and the executive in our country, which provides for the independence of the judiciary. I know that we are pressed with time, and I hope that before I'm kicked out for talking too much, I'm sorry I went a bit beyond the topic, but I'm ready to answer any of the questions you would ask.
Shukran. Thank you. It is a very interesting, different point of view presenting the situation and the historical developments of the justice in Egypt. Following the same line, I would like to pass the floor to Mr. Iyad Chawashi, our guest from Tunisia, please.
I will speak in Arabic. في البداية أود أن أشكر المنظمين.
In the beginning, I would like to thank the organizers for the excellent organization. I would also like to thank personally to the Bulgarian ambassador to Tunisia, and I would also like to pray for the spirit of Muhammad Bouazizi and all Arab martyrs, those without whom neither our souls nor our pens would have been stirred, and we would have been unable to talk about all this today. I listened very carefully to what my friend from Bulgaria said, and I saw that there are many cross points, although problems sometimes are different. I would like to remind you that the judiciary is also one of the forms of transition, of achieving justice or fairness of the transition. And regardless of whether we talk of symbolic forms or something else, anyway, traditional justice is also a way to achieve, to administer justice. Every citizen of this world shall be entitled to justice, to fair trial from an independent court. So, this is an obligatory condition. Justice is the foundation of civil peace. This is something which was not only part of the dictatorship, something that the dictatorship used to impose its power over everyone. In my modest opinion, the decisions regarding the future are related to the past, to the right attitude to the past. Means being away from any excessive sensibility and emotionality. We need to look at the past. We need to learn from the past. Tunisian justice is as old as the Tunisian state. Also, it suffers from all the historical and political heritage that the state experienced. I will mention the Islam law, the French school, and the British school as related to the Tunisian system. In all cases where representatives of the judiciary have been involved in political procedures, they have tried to behave in a very dignified way. The Association of the Tunisian Lawyers played a role under President Ben Ali that started with immediately when Ben Ali came into power and started persecuting civil freedoms. So in Tunisia, the leftists, the Islamist political parties as well, have never been, have never deserved such attitude. They have never given grounds for such persecution. But the regime chose this attitude based on ideological reasons. One of the means to act against the independence of the judiciary was to have people put in key positions. Can you please ask the speaker to speak slowly? This is the request of the translators from the Arabic booth. Please ask the speaker to slow down a little bit. Thank you. Thank you very much. Okay, so we continue. So in conditions of expanding corruption, in 2001, one of our judges addressed an open letter to Mr. Ben Ali asking for his intervention and launching of reforms. The response came very fast, accompanied with more and more persecution and campaigns against civil liberties. Although the only thing we asked for was the independence of the judiciary. But there was no real administration of justice. These were trials against the enemies and opponents of the regime. The situation in Tunisia did not allow the regime to have the author of this open letter put behind the bars immediately. Of course, he was dismissed, he was discredited via the media. The author of this letter became a subject of insults from the media, and his reaction was to a great extent a challenge to the regime. He made us, the chair of the Bar Association made a public statement saying that discrediting the author of the open letter was just an attempt to shut the mouth of the judiciary, and this was a very dignified position. Then there were attacks, repressions against the lawyers who tried to help their colleague. And the Bar Association in Tunisia also took a very dignified position, which made Ben Ali to look at the management of the Bar Association as his personal enemies, even more than the representatives of the political opposition. Ben Ali decided to make a coup against the Bar Association. And that was not that difficult, because in the judiciary there were judges who believed in the integrity of the chairman of the Bar Association. In such conditions, the dictator directed his efforts against the young and the elderly people, honest people, and he was able to really do this coup against the leadership of the Bar Association. A colleague of ours representing a progressive party laid the foundations of a newspaper, a bulletin to be published by the Bar Association. This newspaper turned into a real instrument in the hands of the judges and lawyers in support of their independence. That's how I'm coming, and now I'm heading to the 17th of November, when the civil society and the Bar Association, the Association of Judges had to take a position against the situation. And after the martyr Bouazizi put an end to his life and beginning the revolution, many things changed. And again, the Association of Judges was in the focus of attention, as well as the Bureau of the Association of Judges. They tried to attract the attention to the state of the judiciary. And before Ben Ali was ousted, the Bureau of the Association of Judges issued a declaration against the repressions against the participants in the uprising, the protests, and appealed for respect for law. The Tunisian society looked with hope at the leadership of the Judges Association, and only in the end of October this leadership was reinstated. I will now try to really be very brief. Please give me 2 more minutes because I want to touch upon a very important issue. After all this past filled with suffering and pain, after we shared with you how judges in Tunisia were repressed and persecuted by the political police, and when we saw judges who preferred to write reports against their colleagues, we can only say that the Tunisian revolution led to freeing the judiciary. Ideas about the transition became clearer. And the important thing to mention is the attitude of the Judges Association to the so-called Committee or Commission for Truth with respect to violations carried out by the previous regime, which also included shootings against people participating in rallies and protests. So the justice, if we talk about justice during traditional, instruments and tools must be used, but the chairs of the Committee of Truth, and I don't want to question their integrity, still these committees were founded before the President Ben Ali resigned. So I am not really certain that they can function as required and expected. The chairs and the members of these committees must not be in any way connected to the past. Secondly, I would like to mention a fact, and please, the non-lawyers, pay attention to this, because this exists in international treaties and charters. Members of the Committee of establishing facts related to corruption went to the President's palace and opened the archive without permission from the judiciary. So, colleagues, lawyers, you understand that this was a very serious violation, because this may lead to acquitting the dictator, because they in fact manipulated all files in this archive. And obviously anyone or the president can say, well, how do you want to put the blame on me if you don't have all sufficient evidence? There is need to launch a campaign against corruption. There is political corruption, economic corruption, administrative corruption in Tunisia. And the Judges Association was convinced that we can fight corruption only by removing all corrupted elements from the systems. The Judges Association founded a committee which addressed the chair of the interim government and requested the cleansing of the judiciary system from all corrupted people. But this has not happened. This has not even started. No investigation has been launched. So I cannot blame anyone, neither in Eastern Europe nor the interim Prime Minister of Tunisia, with respect to lustration. One of the most dangerous things is lustration based on the absence of rule of law. We have to provide the judiciary with the possibility to have complete control over all records and files and be free of any pressure. We asked the Minister of Justice, why didn't you open the records? Why didn't you start persecution against the corrupted people? But we know the answer, although we never received it. We know the answer is because the real culprits will be hidden. And last, I want to remind you, because we should remember that the representatives of ours, we need to remember the names of all people who were killed, people from the judiciary system. Now we hear the names of these people, and I hope they rest in peace. Thank you, and excuse me for being so long.
I think this extension was well deserved. What we can see is that the issue of independence of the judiciary, the issue of independence of judges has various dimensions in different countries, but the common ground is there. With this, I would like to pass the floor to our last speaker on the panel, Mr. Taufik Wanez, please.
Thank you, Chairman. I don't know if I'm very lucky to be the last one to speak, because almost everything was said. But however, I am very interested in having some kind of synthesis of the main trends and the main ideas and the main principles who are in fact common to the experience of the Arab countries, and before that the experience of Central and Eastern Europe in dealing with the judiciary after a revolution. In fact, one must confess that the dictatorship, as it has been said by my colleague right now, the dictatorship uses the judiciary in order to establish and maintain its dictatorial or authoritarian practices, and to reinforce the institution, if it is an institution of the dictatorship on the country. So one, with all respect to the judiciaries and to the judges, who are in general, in majority I would say, clean, fair and honest people, the judiciary as a system during the dictatorship has been used and has been involved in the dictatorship. So we should not think that after the revolution this judiciary will take the measures in order to implement a new justice. In fact, before implementing a new justice, one has to set up a judiciary not only independent, any judiciary must be independent, but not neutral vis-à-vis the achievements of the revolutions. In fact, the idea, the old idea, which is unfortunately very deeply rooted, is that the judiciary or the judges are completely independent and they must stay in their ivory bull, and they are just outside of the politics, etc., etc. Of course, they must stay outside the politics in the political sense, but they are part of the society, of its evolution, of its hopes, and of its distresses also. So after any revolution, the judiciary system is also challenged. The confidence in the judiciary immediately after a revolution, the popular confidence is weakened, like it or not. And then I think that there is a need to rebuild or build up the confidence, the trust of the people in the judiciary. And this needs very important and courageous confidence-building measures. And these confidence-building measures, they must be studied, adapted to the situation, adapted to the history of the said revolution, etc. One should also confess and recognize that it was said this morning, as it was said this morning, the judiciary as an institution is rather conservative everywhere in the world, everywhere. And throughout the history, the judiciary is a very conservative institution. So, in view of a transitional justice and in the aftermath of a revolution, serious and deep reforms of the judiciary are more than necessary. Sometimes purges must be taken within to clean up the judiciary as institutions from those who were in fact the judiciary arm for the dictatorship. And in this sense, I was pleased again this morning to hear President Gelougilev, to whom I have asked the question in Tunisia when he was in Tunis during the elections, and I have asked him, what was your first difficult decision after you have been elected as president? And in fact, he told me that the first difficult decision whom he took by himself in a kind of solitude of power is to kind of fire the prosecutor general, and he mentioned this himself this morning. So this is an example on the importance of the reform of the judiciary. Now, there are some challenges for any judiciary after having been purged, reformed, etc. There are very important challenges. In fact, as I said, the judiciary should not be neutral. The judiciary is independent but not neutral. In this sense, I have the pleasure again to quote President Gelougilev, in fact, when he was discussing the adhesion of Bulgaria to the Council of Europe. I am quoting his book, Bulgarie, Terre d'Europe, Bulgaria, Land of Europe, when he was discussing with Miguel Martinez, and he told him, I'm trying to maybe I'll ask the translators because it's in French. He said to Mr. Martinez, Miguel Martinez from the Council of Europe, je peux donc vous assurer que personnellement,
Personally, I will never allow the application of a law which envisaged the prosecution of people for their political convictions or their political affiliation, and I hope that with the help of the Constitutional Court, I will be able to block any texts of such nature.
To the Council of Europe, I mean, had to take very strong stance vis-à-vis the Bulgarian judiciary by saying, I will oppose myself the implementation of any law which is contrary to the basic human rights and based on the discrimination for ethnic or religious or political reasons. So this is one challenge that not only the judiciary has the responsibility of that challenge, but also the other powers in the country post-revolutionary stage. So the legislative, the judiciary, and the executive, they must, in fact, cooperate in the sense to stop any nostalgia to come back or to reinvent any other dictatorial or discriminatory system. So the issue of controlling the constitutionality of laws, this is also very important, and this is part of the judiciary also, because the role of controlling the constitutionality is part of the functions of the judiciary. So the judiciary is not only to, decide on the issues between citizens, but also to see if the laws are, in conformity with the constitutions. And I was very pleased when the president from Egypt said that at one point in time these mixed tribunals, before adopting a law, they must agree to that law, which is, very, very significant. So also, of course, it was mentioned this morning, I'm not going to develop on this one, the revision of the criminal law. But maybe more important, the revision and the strengthening of the administrative law and of the administrative tribunals, because they will be the forum to defend the individuals, the citizens, against the administration. And this is also a very important area in order to implement and strengthen the judiciary in the same line as the revolution achievements. So for this, it's easy to say, but to implement it's a bit difficult, but possible. In fact, the judiciary and the judges, they must stop or get rid from this classical, traditional attitude to, especially I'm talking about our area, to implement only national laws, domestic laws. Because unfortunately, given my personal background and His Honor can also, confirm this, the judges in Tunisia, and I imagine in all the Arab countries, they implement, as you said, Chairman, they implement the law simply, and they implement national laws. And although they know very clearly that international laws, and especially the human rights international laws, are applicable immediately to the citizens, they don't do it. How many times personally I have tried to, argument on basic of the international law, on the basis of the covenants and on the Universal Declaration, and unfortunately no response to that one. I think that this is a matter of education, of changing the mentality of the judges to use these international norms in order to defend the achievements of the revolution and the democratization, because in fact the title is the democratization and the judiciary. So I think that there is now a need to also, and this is my last point, to give the possibility and to strengthen the role of the defense. Because unfortunately also in our part of the world, the defense system is not completely free. The lawyers, the defenders, the lawyers, they are really in a very difficult position because, in fact, the laws concerning the advocates, etc., are in fact very repressive. They are very repressive for, I mean, one more word more, I mean, the lawyer who was pleading a case can find himself immediately going to jail, arrested by the president of, for yes or no. So this is also an important element in order to strengthen democratization, is that the right of defense is strengthened within the national laws. So I think to reach all this, and I think that we should not be afraid from such a big, important challenge, but I think that this is feasible. We need important international cooperation in this domain. We need trainings. We need also a dialogue in order, because any revolution, if it is not reinforced, if it is not reassured by an independent but not neutral judiciary, will have very regrettable effects. Thank you, Chairman.
Thank you very much. I think we heard presenters from different countries, but in different historical moment in their development. But there are, yes, I know. I would like just to, kind of conclusion, summarizing what has been said, that regardless of the differences, there are quite common and solid grounds, like independence of the court or of the judiciary, like the role of the judiciary as protecting and defending the rights of the citizens, respecting the internationally recognized human rights standard, and of course the standards of effectiveness or efficiency of the judiciary. I would like to open now the discussion. I see there are quite many questions. Let's try to get 3-4 questions, then try to answer them, and then further proceed. I think there was a first reaction in this side. Please, gentlemen.
Thank you very much. I've got a comment and question, especially to the last speaker, it seems. Ronald Dworkin, the Anglo-American legal philosopher, he called judges the princes of law. But the question is why we actually focus here on the judiciary and democratization. Because judges, it looks like they are guardians of rule of law. But then it's very easy, it looks like, to introduce some sort of the institutional change which will guarantee independence of judiciary. The more important are the changes in mentality. And it was mentioned here that judges should not be neutral. What does it mean? It means judges supposed to simply support substantive concept of justice. Not only formal, dry one, that they are some sort of the machine in the hands of the state, but they should support the changes which took place. But the question is how to achieve that. It seems to me that this is not only a question of the institutional reforms, not only to decree, basically, in the constitution or in the statutes, but legal education. But not only legal education. When you mention direct application of international law, that require change in the perception of the world by judges, sort of the change of the hermeneutics. So how to achieve that, probably nobody knows. Maybe some suggestions. Thank you.
Thank you very much. Yes, please. Please pass the microphone.
شكرا. هتكلم بالعربي. أنا محمد زارع محامي من مصر. كلامي موجه
I come from Damascus, a lawyer, the role of the court prior and post-revolution. Before the 21st of January, there were extraordinary proceedings, court proceedings. Many judges issued verdicts, sentences. They ruled out when there were problems during elections, rigged elections. But many of these sentences were rather strange. I witnessed such sentences because I've been working in this area for 20 years. Sometimes there was a person involved in serious crime, and in the end this person just had to pay a very small fine. After the revolution, that is post 25th of January, many young people, charges were pressed against many young people who were involved in the protest on the square. The chief prosecutor is still in power. Many strange things happen. These extraordinary proceedings still exists. I mean military courts that employ very fast procedure with very fast sentences. And simultaneously, when we talk about the sons of Hosni Mubarak, they were sued in regular courts. And then information provided or evidence provided is, by officers is not completed. It's forged sometimes. I'm talking about two different things. Is there a difference between what happened before the 21st of January and what is happening now after the 21st of January? I am a lawyer. I've been defending 500 people who told me that they cannot rely on independent justice, on independent trial. I'm also a lawyer, and I would like to join my colleague with respect to what's been happening in Egypt, and also what the advisor, Mr. Ahmed Ahi, said. I would like to offer a comparison between the attempt or the experience and the way the judges worked before the revolution and now, because from the standpoint of a transition to a democratic system, for a period of 30 years, there have been attempts to destroy the independence of the judiciary, but the Supreme Council opposed any attempt to revoke the independence of the judiciary. The regime tried again and again to provide additional services and benefits to judges, appoint them for governors, district governors or advisors, but in their work, the representatives of the judiciary, and I have witnessed this, never allowed for the regime to change its mentality and its way or modus operandi. Something else, when we talk about the lack of independence of the judiciary under dictatorship, me as an Egyptian and a citizen of Egypt and a lawyer, I can only say that we did not have police, we did not have a real government. It was good that we at least had a judiciary, because otherwise how would we have lived? I would ask the advisor Ahmed Maki, who is with the Supreme Council of Judges, to continue playing an important role for taking urgent measures in response of the demands of the Egyptian civil society, so that the judiciary works to the benefit of the civil society and the human rights. Judges are those who in their work can implement in practice international criteria, international law and international treaties. Thank you.
I'm speaking Arabic. سيادة المستشار، بخصوص العلاقة المتوترة ما بين شقي العدالة في مصر، القضاء.
Well, about the relations, the tense relations between the judges and the association of lawyers, the Bar Association in Egypt, we sometimes come to a situation when lawyers go on hunger strike, refuse to enter the courts because they are in protest. So the Supreme Council of Judges can play a decisive role in resolving these problems. And sometimes this protest is very logical, because lawyers protest in response of some acts. I myself am an engineer, but I have witnessed how the rights of lawyers have been limited in their professional work. So, when we talk about justice in this extremely important for Egypt transitional period, we need to pay attention to this as well.
I would like to... Yes, please, go ahead.
في حديث للرسول صلى الله عليه وسلم يقول: من ولي القضاء فقد ذبح بغير سكين. أيوة. طبعا قاضٍ في الجنة وقاضيان في النار. وأنا الإحساس العام في كل المجتمعات.
If an Egyptian turns to a judge, it may be a very complicated issue. The judges in all countries take the blame without really being guilty. People who conduct justice are always in the line of fire. We are talking about three powers, and that the judiciary is one of the three powers in society. And this is the supreme achievement in the ideas of Montesquieu, something we believe, and we cannot imagine, as the gentleman said, we cannot imagine a legal system, a judiciary which is completely neutral. Can the judiciary be completely neutral? The administration won't be independent and neutral. The legislation is a very important activity. It's the function of Parliament. But imagine if an extraordinary act or law is adopted which gives extraordinary powers to certain courts or tribunals. This would limit the powers of the third power, the judiciary. As you know, there is a philosophy about how the judiciary could be handled in despotic regimes. And this has been written in a report of the United Nations of 1985. There are certain means and instruments through which a despotic regime could establish control over the judiciary by limiting the financing, the funding of the administrative proceedings and the administration of law, by provoking arguments and disputes. And I have experienced all of this because I've been working in the legal system for 50 years, and during these 50 years I've been subjected to all these aspects. During Sadat and during Nasser, I have been subjected to all of the above. I've been subjected to hostility or to suddenly too strong friendly attitude, which is also inexplicable. 14 days before the revolution, I was treated with such a friendly gesture. For me, this was a very big surprise, because last year I had rejected such a gift already. So let me answer the questions which are a bit scattered, a bit diverse. Please do not burden the administration of law more than it can handle and more that it could respond to. What could I do if I have to abide by the rules which have been prescribed in the laws? Can one be revolutionary against President Mubarak, or could you revolt against the former president of Bulgaria, Todor Zhivkov, and in the same time to work as a judge? There are laws which must guarantee the freedoms and the right for the judiciary to function properly. Since 1960, in Egypt, we have no other possibility to perform our functions except by thinking under this way. And our revolution is a revolution in the name of social justice. We suffer from the power not of the state, but the state machine, who is corrupt as well, jointly with the power of capital. In such a system, in your revolutions, you aimed at other things, at free market relations. We are fighting for elementary social justice because During the Mubarak regime, it was time of the excessive power of capital. Therefore, Egyptian justice has its specifics. Lawyers were the engine of the protests in Egypt. Makram Obeidi, during the 40s, was one of the lawyers who defended the idea of the independence. Another lawyer who also insisted on this, on the independence of the judiciary in Egypt. With the existence of all sorts of courts and tribunals, normal military, trade tribunals, the regime had to conclude that the unity of law administration, when we have a government, one Minister of Justice, how could you have 5 or 6 systems of tribunals and courts if you only have one institution as the Ministry of Justice? The authority always defends its agents, its servants. In 1965, we disclosed a coup against an attempt for a coup against Nasser, President Nasser. And later we received a piece of information that the future then President Sadat, who inherited the presidential post, insisted and wanted bigger trials and the removal of many more people, but Nasser refused to do so. In 2006, the chairman of the Supreme Judicial Council tried to oppose, to protest against the presence of 20 or 30 judges which were involved in the forging of the elections then. And they had to be tried in court with for forging and tarnishing the authority of justice. Our attitude to those lawyers which you mentioned is that your protests have no foundation. All the examples from the history which I am quoting and mentioning, and which I mentioned before, are related to the fact that the judge himself has to choose his assistants in the proceedings in court, and the public must know the past of the people he's going to select for his assistants. So if you follow the history, you will notice that politics and politicians always, when they interfere, they do it for political reasons, and this never leads to anything good. If you look at the history, it's always the President of the Republic who bears the supreme responsibility, the highest responsibility for all cases of repressions and tortures in the state. If the prisoners have blindfolds or if they're tortured in the prisons and they're blindfolded so they can't see who's torturing them, if any of them are subjected to beatings and they can't see who is doing it, this is the responsibility of the ruling people, of the people in power. If you choose for your legal advisor a lawyer with a 60-year practice, he will be obligated to tell you the truth. Thank you for your attention.
I would like to try to reply to the first question concerning the, well, whether judges can be neutral, and also how about a change of mentality?
Yes, I think that, in fact, I must be clear. I say that the judge must be independent, and this is the cornerstone of the system. But in transitional justice, the judge should not be neutral vis-à-vis whom? Vis-à-vis the achievements of the revolutions, vis-à-vis what the people and the legal system acquired or could acquire from the revolutions in the adhesion of the basic human rights principles and the norms. So this is a little bit to make a kind of comparison in international humanitarian law. The ICRC, the International Red Cross, and Red Crescent societies, they are independent but not neutral vis-à-vis the victims. In fact, the neutrality is not to be confused with the independence. The neutrality is that you should not be neutral. It means that the victims do not interrogate your conscience and your work, your implementation of the law. So this is the notion of, I mean, that the judge should not be neutral. And in the same vein, I think that we should also make very clear that a lot of practices, they were in a kind of independent and the implementation of the law, because how many, I mean, cases they were judgment or decisions based on pseudo common law issues, but the objective is political. The objective is political. If you want to really, I mean, put some dirt on a person or etc., you don't say that this is a political trial. You say that this is just common law trial, and you say that he embezzled, I mean, money or he was a thief. So I think this is now a real danger. This is a real danger, because I think that there are some cases of requests for extraditions which are in fact, I mean, behind this screen of common law. There is a kind of of cases. I mean, it was mentioned by His Honor, my colleague from Tunisia, that the answer to this is not simply to say, okay, let's concentrate on the president or on his family, but there is no concentration, I mean, there is no focus, if you want, on the corruption as a system. There is no focus on dictatorship as a system. There is no focus on the government as, I mean, being the systematic, I mean, torture, systematic discrimination, etc. This is, I mean, neutrality, this is, and how to do it, of course, that's very important. I can only agree with you. It's a question of education. I said that very clearly. And it is also, maybe we can make some decisions. For example, example, that some laws should give to the High Court, for example, the control of the other the jurisdictions on when the issue of international human rights is raised by the lawyers or by the victim himself or herself. I mean, there is a need that there is a control. So there are a lot of techniques in order to change the mentality, because a judge from the primary court or from the appeal court, when he knows that at the High Court his judgment, if the judgment does not take into account the international human rights law, his judgment will be revised. So there are a lot of techniques, and this is maybe a matter of another discussion.
Indeed, time is pressing. We are largely behind schedule, so I would like, and I have been given clear sign by the organizers to kind of terminate the panel. I would just like to give the floor for the final comment concerning the change in mentality, because basically this is perhaps the core of the transition, the core of democratization of the justice, the mentality, the evolution, the change in the mentality of the judges. And of the society, of course. Nelly, perhaps?
Well, as you're looking at me, I will say a few words. Thank you for passing me the floor. I was a judge during the totalitarian regime. I joined the system in 1984, and probably I have already went through this period of changing mentality. I think it is difficult for the society, not only for the judges. Judges are part of the society, obviously, to change their mentality. But I look at this change of mentality as an attitude to universal human values. What is more important? To be liked by the person in power, the one who heads the country, or try, under the law, to provide justice to the people. Of course, in a dispute, there is always a winner and a loser. Everyone has an individual feeling about justice. I want to share with you something that I learned about yesterday, because I was in the International Tribunal in The Hague. I read some articles about Kenya, about the criminal proceedings against a very prominent figure, and I understood that serious charges were pressed against him: murder, torture, rapings. And I am now not talking as a judge, but rather would try to speak from the shoes of the Kenyan society, because the people were impressed by the fact that the court was independent. This is a near quotation. The judge was a Bulgarian. She's an example. She's an expert on pretrial procedures. She paid specific attention, Judge Trendafilova, to the victims, but also she provided full right of defense to the defendants. And it appeared that the people in Kenya, who in fact live in camps because they do not have ordinary homes, they they watched the trial in the parks. And the representatives of the ICC told us, International Criminal Court, that when the defendant tried to voice political speeches, the judges said, well, this is a courthouse. There are rules, and you will be entitled to say everything you want in your defense, but now sit down, please. The people in the Kenyan park applauded, and they did it because they saw this person who is untouchable, who was untouchable in their country, was forced to respect the rules, and rules are neutral. So probably we do speak different languages, not only Bulgarian and English, but also what a judge understands by neutrality. Sometimes we judges want to kind of cry together with the victims. I have colleagues, very sensitive women, because when there is a trial about mutilated kid, children, they cry in court. But the reality is that we need to be neutral and provide equal rights to both sides to a trial. So probably we need to clear the term neutrality of the court.
بخصوص قضايا الضحايا ومحاكمة الرئيس حسني مبارك أنا قلت
with respect to the victims and trial against Hosni Mubarak, I have two personal wishes. It is important to understand that the prosecution is part of the executive power. And in our project for judiciary, we insist that the prosecution becomes independent from the executive power. Secondly, we need to know that in order to collect evidence, the prosecution relies on the police, and the police is also a defendant, and a defendant cannot collect and will not collect evidence against oneself. I'm going back to the title of our forum, because we're talking about winning the future. We need to know what the past was, close the door, and successfully do the transition. Only then we will start building the future. Of course, this will take some time. I understand that the Egyptian people and all other Arab people have bleeding wounds, and our Bulgarian friends speaking about revenge against a person who is already dead. You are angry that these people, this person was never charged with the right charges, while we Egyptians still live in a society where the police is present in the streets, the police that needs to collect the evidence, and even the judiciary system, which self-sanctioned itself in order to implement the principle of illustration, is still functioning in a society which has not completed its revolution. I understand our Syrian friends who want to cut the throat of Bashar al-Assad, but we need to implement the principles of justice.
I think it deserves a whole conference on its own, but let's respect the realities. Thank you very much. Thanks all the panel members for their presentations and participation. And I would like especially to ask for your applauses for our translators who managed to translate this debate. Thank you.
One small notice: dinner will be served in the hall opposite to here. In an hour's time, Julian Popov, who is here, is going to talk about the School of Politics. This is an instrument that has become very popular in our region. So whoever of you is interested in this, Julian Popov will be expecting you in Rila Hall. Thank you. And we'll keep you working.